In this video, I'll show you January 8, 2024, law student Joel Martinez, who we met in a previous episode of ATA that I've linked in the description for this video, was working with a locksmith to gain entry to his vehicle after losing his keys in a junkyard in Anthony, Texas, when he was approached by a deputy with the El Paso County Sheriff's Office who was responding to a call. The interaction that followed was captured on the deputy's body camera.
Hello. Buenas noches. José Méndez, mucho gusto.
¿Cómo está?
Bien, how you doing, brother?
Doing good.
All right.
Yeah.
¿Tienen problemas con el carro?
I lost the keys in the junkyard over there.
Okay.
So I called them to come and get the...
To come open the gate?
No, the key. The car. The car is the one that lost the keys.
Oh, like you went into the property and you dropped the keys?
Yeah. I was in there doing, like regular junkyard stuff, looking for my parts. When I was leaving is when I found out I didn't have my keys. They let me go in, look for them all over the 30 acres of cars they have.
Okay.
Didn't find them, so they just grabbed the tractor and moved the car outside so I could call them locksmiths.
That's weird, yeah, because we got a call with a gentleman with your description. That's why, on the property. Were you the only one on there?
Yeah, well, I was here and the car was closed, so I couldn't get out.
So let me understand, is this car yours?
I just bought it, brother.
You already bought it?
Yeah.
Okay. But they closed the gate behind you or what?
Yeah, they just moved the car here and they closed the gate over.
Okay. What's your last name, brother?
Just Martinez.
I'm sorry?
I don't want to give I didn't invite any information. I'll just give you my first name, Joel.
Well, I need your info, man, because I'm talking to you, brother, because you're the person that they called on, so...
I'm not going to give my information right now.
Okay, why not? I'm just asking you because you're the person they called on. I need to find out who you are, and you're telling me one thing, so I got to call the property manager and ask them if they were the ones that allowed you on the property.
Yeah, that's the investigation, right?
Yeah. So I need your name, brother.
You could just call the property man. And
do you have an ID?
I do.
You mind if I see it?
I do.
Okay, why is that, brother?
I'm not legally provided to give you the full name. I'll just leave it at the last name, bro.
Since I'm investigating what's going on in this property and you're the one that matches the description,
yeah.
I need to know who I'm talking to. Now,
okay.
if you want to take this further, you want to complain, you want to whatever, if you fail to ID yourself, I'm asking you lawfully to see who you are. If you want to impair my investigation, that's fine, that's on you. Okay, but I don't think you want to take it to that extent, brother. For giving me your name and date of birth. Okay, so I'm going to warn you now. Warn you now, brother. You don't give me your ID or your full name, I'm going to arrest you for failure to ID.
Okay, so
because I'm investigating, brother. That's all I'm doing.
Okay.
All I need is your name and date of birth, brother. That's it.
Under the
I'm not asking you. I'm not.
And I'm a law student here too, so
perfect. I'm not asking you for a blood sample. I'm not investigating.
Calls are not reasonable, articulable suspicion to suspect of a crime under Florida versus JL under the Supreme Court.
But I'm not here to argue with you.
Yeah, I'm not here to argue. I'm here to defend my rights.
So I'm asking for your name
and it's not impeding your investigation because it's not a physical, or it doesn't. Giving you my ID doesn't help.
You're in law school, right? You're a law student? Okay.
Yes, sir.
Now you're making it bigger than it is because all I'm asking is for a name and date of birth. You have to identify yourself, man. You're making
Texas is more.
You're making this bigger than it is, brother.
That's okay. We go on our way, man.
All I have is Martinez.
Okay, my name is not going to help you in your investigation, first of all.
Well, yeah, but I made contact with you, brother. That's the only thing.
Contact is not enough reasonable suspicion for you to seize my identification.
You're not being placed on arrest or anything, brother. Okay. I'm investigating, okay?
Okay, but are you asking for my identification or...
I'm asking you for name and date of birth. That's all I'm asking for.
Asking, right?
That's it, brother.
Don't answer questions.
What's going to happen is, dude, I'm going to place you under arrest for failure ID, okay? And that's going to be on you, not on you, brother.
So you already said that it's going to be under arrest?
Yes.
Go ahead, be under arrest if I don't give you my identification?
Go ahead and turn around, brother. Go ahead and turn around.
So I'll give you my ID right now.
Go ahead and turn around. No. Put your hands on the car. You already failed to identify yourself, okay? Give me your left, give me your right arm. You want to play games, brother. I'm here being nice. And you don't want to give me your name and date of birth.
After Mr. Martinez refuses to provide his full name and date of birth, the deputy places him under arrest. According to Section 38.02 of the Texas Penal Code, which codifies the offense of failure to identify, quote, a person commits an offense if he intentionally refuses to give his name, residence address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. The statute also prohibits intentionally giving, now quoting again, a false or fictional name, residence, address, or date of birth to a peace officer who has lawfully arrested the person, lawfully detained the person, or requested the information from a person that the peace officer has good cause to believe is a witness to a criminal offense. As Mr. Martinez was not under arrest at the time that the deputy requested his name, and he did not give a fictitious name, it is almost certain that a court would determine that the deputy did not have probable cause to arrest Mr. Martinez for failure to identify. Likewise, under Section 38.15 of the Texas Penal Code, which describes the offense of interference with public duties. A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. However, the statute also states that, now quoting again, it is a defense to prosecution under this section that the interruption, disruption, impediment, or interference alleged consisted of speech only. And in the 2004 case of Adams v. Prater, the U.S. District Court for the Northern District of Texas concluded that officers did not have probable cause to arrest an individual for interference with public duties because he refused to identify himself when he was not under arrest. Similarly, in the 2000 case of Kearney v. State, the 3rd District Court of Appeals of Texas held that an individual who argued with police officers about the constitutionality of a search did not violate the interference statute. In reaching this conclusion, the court noted that, quote, it is observed that Section 38.15 expressly provides in subsection D a defense when the interference consists of speech only. Even without this statutory defense, a verbal interference with a public servant or officer could be defended on grounds of the First Amendment to the United States Constitution. Accordingly, it is likely that a court would determine that the deputy also did not have probable cause to arrest Mr. Martinez for interference with public duties or any other crime for that matter.
I'm going to read your Miranda.
This is your car so we can impound it?
Yeah, it says he just purchased it. No, you're staying right there because you're going in my unit. All right, go ahead and take a second there.
First time on the back of the car.
Oh. Man, you say you're a law student, bro. Pues.
And you'll
That's
see
all you had to do.
You'll see when we get to the station. You'll see when you get to the station.
That was in his wallet?
Yeah. Impound it, sir?
Yeah, impound the vehicle. It's his, so you can tell this guy to take off. He doesn't need to be here. All right, Mr. Martinez, before we go to the station, I'm going to read you your rights, okay? With these rights in mind, do you wish to talk to me?
No, I don't answer questions.
Okay, perfect. I'm going to take him to the station, okay?
Hey,
What's up?
hold on, we're searching your car.
Did you have keys on him?
No, there's no keys. Supposedly, he was telling me that he lost them inside. He just bought this car from inside. He was in there looking for parts, and he dropped the keys in there. So he's waiting. He was waiting for a locksmith to start the car. So I need to call the owner to see if it's true.
So what do you want to do? You want to impound it or what?
This car, yeah.
The deputies search Mr. Martinez's vehicle and the arresting officer tells them to impound it. In the 1976 case of South Dakota versus Opperman, the Supreme Court determined that warrantless, quote, UN, quote, inventory searches of vehicles that are being lawfully impounded generally do not violate the Fourth Amendment. In reaching this conclusion, the court explained that, quote, when vehicles are impounded, local police departments generally follow a routine practice of securing and inventorying the automobiles as contents. These procedures developed in response to three distinct needs: the protection of the owner's property while it remains in police custody, the protection of the police against claims or disputes over lost or stolen property, and the protection of the police from potential danger. However, in this situation, there are several reasons why the deputy's search of Mr. Martinez's vehicle could not be justified as an inventory search. First, the inventory search exception to the general requirement that officers obtain a warrant before searching a vehicle only applies to vehicles that are being lawfully impounded because the officer is likely did not have probable cause to arrest Mr. Martinez, making his arrest illegal. A court would likely find that the subsequent impoundment of the vehicle was also unlawful, thereby rendering any inventory search illegal. Additionally, the deputies appeared to begin the search before they knew that the vehicle was being impounded, as they asked the arresting officer what he wanted to do with the vehicle while they were already in the middle of searching it. Now, although officers sometimes have the authority to search an individual's vehicle after their arrest, as the Supreme Court explained in the 2009 case of Arizona versus Gant, quote, police may search a vehicle incident to a recent occupant's arrest only if the arrestee is within reaching distance of the passenger compartment at the time of the search, or it is reasonable to believe the vehicle contains evidence of the offense of arrest. When these justifications are absent, a search of an arrestee's vehicle will be unreasonable unless police obtain a warrant or show that another exception to the warrant requirement applies, as Mr. Martinez was clearly not within reaching distance of the vehicle when it was searched, and it is improbable that the vehicle contained any evidence regarding Mr. Martinez's alleged failure to identify. It is highly unlikely that the search of the vehicle would fall under this exception to the warrant requirements. Likewise, although officers are authorized to search an automobile when they have probable cause to believe that it contains contraband or evidence of a crime, the deputies here did not appear to have any reason to believe that there were any illegal substances or evidence of a crime inside the vehicle. As such, it is likely that a court would determine that the search of Mr. Martinez. His new car violated the Fourth Amendment.
Hi, sir. So I'm the supervisor here. I was just made aware of what happened.
Yeah.
So I don't think it qualifies for any crime, okay?
It doesn't qualify for a crime?
I'm gonna go ahead and release it.
Of course. I want that officer's badge number.
Yeah,
This is unacceptable. It did not constitute a crime. Look what he did.
Let's work talk over here.
Oh.
And the light's working.
My belongings?
Let me go get it.
Yeah.
Like I said, I just got here.
Yeah.
And I was just briefed of the incident. So I'm trying to get all the facts of what happened.
Yeah.
What happened? Walk me through what happened.
Okay, so as I'm in the junkyard, you seen how big it is. I lost my keys in there.
Yeah, you can
Somewhere.
go parts of it.
Yeah. Lost them, couldn't find them. They gave me a chance. It was like, they closed at 5. It was like 4:30. And I was like, please let me in. Like, I fine, go. They looked and they picked me up on the truck. They said, hey, the alarms are going to activate automatically. You need to get out. What about your car? Because it was parked inside the property. So the owner or one of the employees gave me 3 choices. Like, okay, or we could get a tractor or one of the forklifts to move your car right outside. And like, if you can move my car right outside, so I could call the locksmith, it would be fine. The locksmith got there. We did everything right. And then I just see a patrol. I'm like, whatever. I get down and it's like, hey, like, oh, we got a call and that you were inside the property. And then they say, okay, what's your name? He's like, what's your last name? Martinez. And he's like, okay. What's your first name? We're like, oh, I'm not going to give it right now. He's like, okay. He's like, why not? But I'm not going to give you my name out because I'm not legally required to give it to you right now. I'm a law student. I let him know too. An MSU criminal justice major. An anonymous call or a call is not enough reasonable articulable suspicion to articulate a crime, because RAS is only based on the facts known to the officer, right? If you ask me what's your name, I'm gonna just say I don't answer questions. But if you demand me my ID, give me your ID or I'm gonna arrest you, or give me your ID, I'm gonna arrest you, that's enough. That's all I need. I can get that on the phone and be like, okay, that's enough. Show it to my attorney, and that's enough for the litigation. He said, if you threaten me with arrest, I'll give you my wallet. Right, I'll give you my ID right now. He's like, no, turn around, push me into the car, boom, put your phone down. Set it up on the windshield, put your phone down. Grab me, tie me up. He arrests me, makes fun of my studies, makes fun of everything. He's like, okay, you think it's funny now? When we were over there too, I told him, call your supervisor. You don't need a supervisor, just turn around and put your hands. All this could have been saved if you would have called you. They also searched my car without consent.
As far as searching it, I understand that the deputy made a mistake.
But when it's an unlawful arrest, that makes an unlawful search. It's an unlawful. This whole thing was unlawful. The moment he put his hands on me, that was unlawful. This whole situation became unlawful.
The deputy made a mistake. That's gonna be addressed, of course.
Well, where's the deputy? You said he was gonna be here.
He's here, but I want to meet with you first.
Okay. Well, I give you my side. I would like to hear the deputy side right here.
Okay.
If that's fine.
As far as your car, there's your property.
I have your stuff right here. Your phone, your wallet, your AirPods.
Yeah, you can hand this over. Yeah. Thank you. Yeah. I have the videos here.
I believe you. I'm not
everything.
saying I don't. As far as us, My understanding, someone called and said that there was suspicious activity. I get it, it's not a crime.
It's not.
But that's enough reason to detain someone.
Not detain.
As far
It's enough reason to make contact. When you illegally detain someone, that's already a cease of someone's person because you temporarily are ceasing that person onto your authority. Because if you tell me I'm detained, I can't walk off, right? But if someone calls and say, "Oh, I saw this guy that looks like me right now, jumping a fence," that's enough for you to say, "Hey, you're matching a description. Where were you?" That's a consensual encounter. You don't
No, it's not.
You don't go and say, "Hey, you're detained because we suspect you of trespassing," because suspicion is based on the facts known to the officer.
That's
Not
enough
to the. That's enough for what?
That's enough. So the detention was off, what you're saying? The detention was the fellow ID in the arrest was not. The supervisor argues that although Mr. Martinez's arrest was illegal, the underlying detention was not. As we have discussed earlier in this episode, it is highly probable that Mr. Martinez's arrest violated the Fourth Amendment, as the deputies likely did not have probable cause to believe that he had committed a crime. However, it is less clear whether the deputies had the reasonable suspicion necessary to lawfully detain Mr. Martinez. Based on the call received, it is important to note that the mere fact that an officer responded to a 911 call is insufficient to establish reasonable suspicion on its own. Rather, as the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, explained in the 2010 case of U.S. versus Gomez, quote, "Whether a 911 call provides reasonable suspicion to justify a stop is determined on a case-by-case basis," and now quoting again, "Whether an officer has reasonable suspicion must be based upon the facts known to the officer at the time." The court also noted that under the Fifth Circuit's precedent, courts must consider 4 factors in deciding whether a 911 call provides a sufficient basis for a stop. Now, quoting the credibility and reliability of the informant, the specificity of the information contained in the tip or report, the extent to which the information in the tip or report can be verified by officers in the field, and whether the tip or report concerns active or recent activity or has instead gone stale. When it comes to anonymous tips, the court explained that, quote, "If a tip is provided by anonymous informant, such that the informant's credibility and reliability cannot be determined. The government must establish reasonable suspicion based on the remaining factors. An anonymous informant's ability to describe a person's appearance and location is insufficient without more to create a reasonable suspicion of criminal activity. This court has observed, however, that where instant caller identification allows the police to trace the identity of an anonymous telephone informant, the ready ability to identify the caller increases the reliability of such tips. Now, because we have very little information about the substance of the 911 call, including whether or not the call was anonymous, it is impossible to anticipate whether a court would conclude that the officers had reasonable suspicion to detain Mr. Martinez. In reaching a decision on whether or not the officers had reasonable suspicion, a court would perform an exhaustive review of the details provided by the 911 caller, along with their identity and relationship to the property, and what parts of that information was communicated to the deputies when they were dispatched to respond to the call. He came on Love because he...
First off, he never said that I was detained. So as far as I'm concerned, I could have walked off. Because if you're just asking or it's a consensual encounter, I can make it unconsensual and just walk away.
What are you looking for?
I'm looking for a story now, and then I'll tell you what I'm after it. I'll let you know what's going to happen.
Okay, let me wait with him and then I'll be back, okay? His story is basically your story, pretty much.
Well, okay, let's put it this way. If he comes here and apologizes to me, I won't litigate this whole thing.
It's up to you, since I'm obligated to investigate any type of complaints. I don't think it was best, but if you want to go that route, we can definitely go that route. All right, give me 1 second.
It'll be perfect. Yes, Mr. Fortune. So, have anything to say to me? No? Didn't I tell you that what you were doing was unlawful? Did you believe me?
Yes.
Did I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unlawful? Didn't I tell you that what you were doing was unl No,
It's not that I didn't believe
Okay.
you. I
Did
say
you get the supervisor when I asked you to?
Okay.
No, you said I didn't need one.
No, I never said.
It's on your body camera. It's on my phone.
Yes,
Don't
you
lie.
asked for a supervisor, but what did I tell you?
You said you don't need one.
And I'm in the wrong. I really am. I'm not gonna lie to you, brother. Okay?
You are in the wrong, and I told you were in the wrong, and I told you you were gonna, and I told you all this, and you thought it was funny.
And I never thought it was funny.
No, you laughed because you unlawfully arrested me. It wasn't a mistake. He broke the law. It's not a mistake. That's gonna get FOIA request, your dash cam in your car, everything, and that's gonna go straight to my attorney. And you lost your qualified immunity right now. Right now,
Okay,
you're by
sir.
yourself.
So it's getting out of control. You said something different to me before. Take off. I will take your complaint.
Do you have the complaint form? I can fill out.
No, I have to fill out myself.
I'll
So you're
just-
gonna take you to your car as far as the locksmith?
Well, I'm actually getting picked up here.
Do you want to get picked up here, or do you want me?
I don't have the key on the car. I was working, there was a locksmith there helping me get a key for my car because I lost mine in the junkyard. So, like, that car's immobile right now. I can't move it. That's another
So
thing.
you need him?
Well, I really don't.
Mr. Martinez shared it on his YouTube channel. The results of Mr. Martinez's complaint are unknown, and although Mr. Martinez made it clear that he intended to file a lawsuit during the interaction, no updates regarding any legal action by Mr. Martinez are available. Overall, the deputies get an F for demonstrating a complete lack of knowledge regarding basic Texas criminal laws, unlawfully arresting Mr. Martinez when he clearly did not commit a crime, and searching his vehicle in likely violation of the Fourth Amendment. The arresting deputy also utterly failed to provide Mr. Martinez with a sincere and meaningful apology when given the opportunity to try to make things right. It is nearly unquestionable that the deputies violated Mr. Martinez's Fourth Amendment rights by unlawfully arresting him, and a lack of humility demonstrated by the arresting officer when confronted with his mistake was simply unacceptable. Additionally, the fact that none of the deputies seemed to know the requirements of the failure to identify. Statute is astonishing and suggests a deficiency in training and officer education at the El Paso County Sheriff's Office. The supervising officer gets an A- because although his attempts to ameliorate the situation were a bit clumsy and ultimately failed, he did immediately release Mr. Martinez after learning of his unlawful arrest and tried to resolve the problems created by the deputy's mistakes. That being said, I cannot evaluate the supervisor's claim that the deputies had reasonable suspicion to detain Mr. Martinez. So I cannot comment on his understanding of the relevant constitutional law. However, the supervisor at least knew enough about Texas law to understand that individuals cannot be arrested for refusing to identify during a detention, and I commend him for his willingness to admit to his deputy's mistake and release Mr. Martinez. We have seen several previous interactions on this channel where supervisors have blindly supported the actions of their officers, and it was refreshing to see a supervisor who was willing to correct a mistake made by the deputies under his command. Mr. Martinez also gets an A- because although he did not seem to be aware of the requirements of the Texas failure to identify statute and could have exercised his right to remain silent more effectively, he maintained a respectful but firm demeanor throughout the encounter and fiercely advocated for his Fourth Amendment rights. The fact that Mr. Martinez focused on the legality of the detention rather than the fact that he had not been arrested indicates that he did not know that the Texas statute only prohibited the refusal to identify after an arrest. But as Mr. Martinez lives in New Mexico, where the Stop and Identify statute does allow for arrests based on the refusal to identify during a lawful detention, this confusion is understandable. However, this encounter does demonstrate the variation that exists between state criminal statutes and the importance of knowing the laws of other states when you visit them. I applaud Mr. Martinez for his tenacity and his commitment to his legal rights, and encourage him to continue in his studies and his constitutional advocacy. Let us know if there is an interaction or legal topic. Thank you very much for watching the video. Subscribe our channel for next video.